How the Crown Rules the World by Mark Owen. There are two crowns operant in England, one being Queen Elizabeth II. Although extremely wealthy, the Queen functions largely in a ceremonial capacity and serves to deflect attention away from the other crown, who issues her marching orders through their control of the English Parliament. This other crown is comprised of a committee of 12 banks headed by the Bank of England House of Rothschild. They rule the world from the 677-acre, independent sovereign state known as the City of London, or simply the City. The city is not a part of England, just as Washington, D.C., is not a part of the USA. The city is referred to as the wealthiest square mile on earth and is presided over by a Lord Mayor who is appointed annually. When the Queen wishes to conduct business within the city, she is met by the Lord Mayor at Temple Templar Bar, where she requests permission to enter this private, sovereign state. She then proceeds into the city, walking several paces behind the mayor. Her entourage may not be clothed in anything other than service uniforms. In the 19th century, 90% of the world's trade was carried by British ships controlled by the Crown. The other 10% of ships had to pay commissions to the Crown simply for the privilege of using the world's oceans. The Crown reaped billions in profits while operating under the protection of the British Armed Forces. This was not British commerce or British wealth, but the Crown's commerce and the Crown's wealth. As of 1850, author Frederick Morton estimated the Rothschild fortune to be in excess of $10 billion. Today, the combined wealth of the banking dynasties is $300 trillion. Today, the bonded indebtedness of the world is held by the Crown. The aforementioned Temple Bar is the juristic arm of the Crown and holds an exclusive monopoly on global legal fraud through their bar association franchises. The Temple Bar is comprised of 4 Inns of Court. They are the Middle Temple, Inner Temple, Lincoln's Inn and Gray's Inn. The entry point to these closed secret societies is only to be found when one is called to their bar. The bar attorneys in the United States owe their allegiance and pledge their oath to the Crown. All bar associations throughout the world are signatories and franchises to the International Bar Association located at the Inns of Court of the Crown Temple. The Inner Temple holds the legal system franchise by license that bleeds Canada and Great Britain white, while the Middle Temple has license to steal from America. To have the Declaration of Independence recognized internationally, Middle Templar King George III agreed in the Treaty of Paris of 1783 to establish the legal crown entity of the Incorporated United States, referred to internally as the Crown Temple States Colonies. States spelled with a capital letter S denote T. Bearing your name spelled in all capital letters means that you have been enfranchised and have the status of a corporation. A juristic personality has been created, and you have entered into multivariant agreements that place you in an equity relationship with the Crown. These invisible contracts include birth certificates, citizenship records, employment agreements, driver's licenses, and bank accounts. It is perhaps helpful to note here that contracts do not now, nor have they ever had to be stated in writing in order to be enforceable by American judges. If it is written down, it is merely a written statement of the contract. Tax protesters and the coming draft resistors trying to renounce the parts of these contracts that they now disagree with will not profit by resorting to tort law fairness arguments as justification. Judges will reject these lines of defense as they have no bearing on contract law jurisprudence. Tort law governs grievances where no contract law is in effect. These private agreements/contracts that bind us will always overrule the broad general clauses of the Constitution and Bill of Rights, the Constitution being essentially a renamed enactment of English common law. The Bill of Rights is viewed by the Crown as a bill of benefits, conferred on us by them in anticipation of reciprocity taxes. Protesters and resistors will also lose their cases by boasting of citizenship status. Citizenship is another equity agreement that we have with the Crown. And this is the very juristic contract that federal judges will use to incarcerate them. In the words of former Supreme Court Justice Felix Frankfurter, equity is brittle, but we are merely enforcing agreements. The balance of Title 42, Section 1981 of the Civil Rights Code states, citizens shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind. What we view as citizenship, the Crown views as a juristic enrichment instrumentality. It also should be borne in mind that even cursory circulation or commercial use of Federal Reserve notes affects an attachment of liability for the payment of the Crown's debt to the Fed. This is measured by your taxable income. And to facilitate future asset stripping, the end of the 14th Amendment includes a state of debt hypothecation of the United States, wherein all enfranchised persons that's you can be held personally liable for the Crown's debt. The Crown views our participation in these contracts of commercial equity as being voluntary and that any gain accrued is taxable, as the gain wouldn't have been possible were it not for the Crown. They view the system of interstate banks as their own property. Any profit or gain experienced by anyone with a bank account or loan, mortgage or credit card carries with it as an operation of law the identical same full force and effect as if the Crown had created the gain. Bank accounts fall outside the umbrella of Fourth Amendment protection because a commercial contract is in effect and the Bill of Rights cannot be held to interfere with the execution of commercial contracts. The Crown also views bank account records as their own private property, pursuant to the bank contract that each of us signed and that none of us ever read. The rare individual who actually reads the bank contract will find that they agreed to be bound by Title 26 and under Section 7202 agreed not to disseminate any fraudulent tax advice. This written contract with the Crown also acknowledges that banknotes are taxable instruments of commerce. When we initially opened a bank account, another juristic personality was created. It is this personality income and assets that ours agents are excising back to the Crown through taxation. A lot of ink is being spilled currently over Social Security. Possession of a Social Security number is known in the Crown's Lex as conclusive evidence of our having accepted federal commercial benefits. This is another example of an equity relationship with the Crown. Presenting one's Social Security number to an employer seals our status as taxpayers and gives rise to liability for reciprocal quid pro quo payment of taxes to the Crown. Through the Social Security number, we are accepting future retirement endowment benefits. Social Security is a strange animal. If you die, your spouse gets nothing, but rather, what would have gone to you is divided, forfeited, among other premium payers who haven't died yet. But the Crown views failure to reciprocate in any of these equity attachments as an act of defilement and will proceed against us with all due prejudice. For a person to escape the tentacles of the Crown octopus, a thoroughgoing study of American jurisprudence is required. One would have to be deemed a stranger to the public trust, forfeit all enfranchisement benefits and close all bank accounts, among other things. Citizenship would have to be made null and forfeit and the status of denizen enacted. If there are any persons extant who have passed through this fire, I would certainly appreciate hearing from them.